recorded, I guess. Yeah. And I would like actually to give a special thanks to our brilliant speakers for accepting our invitation and taking the time to share your knowledge and experience with us. We greatly really appreciate your contribution and participation. Now I think I would like to invite and introduce the first speaker, namely Professor Leszek Garlicki, who is a visiting professor of law at the Washington University in St. Louis. Since 1968, he has worked at the Warsaw University, was a member of the Warsaw Bar, a judge of the Constitutional Court of Poland, and a judge of the European Court of Human Rights, president of the fourth section in 2011 and 2012. He served also recently as a visiting professor at the Tel Aviv University, Hong Kong University, New York University, and at Yale. Judge Garlicki is vice president of the International Association of Constitutional Law and one of the founding members of the European Law Institute. He lectured at numerous universities in Europe, the United States, Israel, Japan, China, and Hong Kong. He is author or editor of over 300 publications in different languages, including a 5-volume commentary to the 1997 Constitution of Poland and 2-volume commentary to the European Convention on Human Rights. And dear professor will give a speech entitled "The Legacy of Abusive Constitutionalism: What to Do with the Neo-Constitutional Court in Poland." So, dear professor, dear Justice, the floor is yours.
Thank you very much. It's a great pleasure to be here. And this is a particular pleasure that we also have our friends from Ukraine at this meeting. Let me use this opportunity to express our solidarity with your fight and our respect for suffering you are now are subjected to. Hope it will somehow or develop in a good direction in the near future. Now, as far as my, by the way, how much time do I have? How much time do I have?
You are not limited in time. I could say up to 20-25 minutes.
Well,
it will be okay. Thanks.
Right. So let me start with the beginning, namely, as we have also some non-Polish guests, some introduction about the Polish situation might be important. So what is wrong with the court, and why exactly we are talking about not about constitutional courts, but about neo-constitutional courts, and one do we want to do something about these neo-constitutional courts? As usual, history is dangerous because it may take too much time. But of course, we all know 2015, this is the moment when the populist party managed to win elections in Poland, both presidential and parliamentary, and took full control over the political branches of government, which is more or less typical for any democratic system. Whatever, the problem was that almost from the very beginning, a trend towards so-called abusive constitution began to develop. Namely, the ruling majority decided to go beyond the constitutional mechanisms of government by capturing full control over all segments of the state machinery, the idea, of course, is well known of Polish constitution as all democratic constitution is that the system of checks and balances require some bodies to remain separated, even independent from the actual winner of political elections. In the first place, courts, but also public media, civil service, several other institutions which were created in the constitution as separate and autonomous institution from the parliament and the executive branch. This was ignored from the very beginning, and the new majority, on the one hand, was still limited in their actions because they did not have, unlike in Hungary, they did not have a constitutional majority. So what was left was to adopt statutes of parliament, take some actual measures, take some other actions, which to a considerable extent were unconstitutional, or at least constitutionally problematic from the very beginning. The Peace Party, of course, realized that constitutionality may be a problem. This was one of the reasons, again here, like in Hungary, one of the reasons why courts became the first targets of a capture of a political absorption. It was very clear that once the constitutional courts particularly will be given an opportunity to decide on those new measures, there's a very high probability those measures would be found unconstitutional. This was something the ruling majority did not want to have. Remember, we are talking about a special version of let's say, hybrid political regime, abusive constitutionalism, namely a system which still pretends to act within constitutional or legal rules. This is the difference from, let's say, naked authoritarian systems that simply simply don't care about it. Here, the pretense was this is everything within the law. The only problem was that this law had to be twisted, abused, so abusive constitutionalism, and the constitutional court was clearly not ready to go. So the first target, the first measures, the very start, the controversy about 5 new nominations to the constitutional court, the very, let's say, end, it was clear that at least the 3 new judges appointed by the new majority are problematic as far as the legitimacy of their appointment was concerned. The Constitutional Court was able to fight about 14-15 months, but then consecutive legislative action, personal changes resulting mostly from the end of terms of office of particular judges created changes the balance of power within the court. In the beginning of 2017, the court already had new president who was not hostile, not very much hostile towards the new government, and majority of judges who were able to control the case. This was the background. Some moves were unconstitutional. Some moves could be regarded as a normal consequence of a change in parliamentary majorities. Remember, the judges are appointed by the parliament. So this still could have been regarded as something fitting to the widely understood style. What, however, was the problem was the reality of the function of the Constitutional Court, and it transpired slowly that they are at least 4 or 5 different dimensions where what the court has been doing was a problem. One, composition. At least 3 judges were not elected in the correct manner. Later, it was also found that at least 3, maybe 4 new judges do not have sufficient legitimacy to be judges. They were mostly former members of parliament and members of parliament with a very definite political opinions about many cases which later they had to decide about in the parliament, and also very definite political opinions about European Union integration, etc., etc. To what extent they could be regarded as impartial? This was a very good question. Then the next dimension was the leadership of the court, president. The president was elected in a problematic procedure, one of these new measures of the government. So, of course, it was easy to get a new president for the ruling majority, but whether this election was fully legal, a very good question. Next, the question of a procedure situation. The court more or less followed the procedure it also has had followed before. There were several manipulations. Composition of the judicial what is decided in particular cases, changing of judges' rapporteur, changes in the composition of some panels. This all was unheard of, and this all made an impression that the court is somehow manipulated to bring the decision which was expected from the court by the political. Then the problem of timing. The court operated in a, let's say, logical timeline, but only if this logic was a political logic of the ruling parties. When it was not necessary, the court was silent. When it was necessary to be silent, because this was in the interest of the ruling camp, the court was. When it was necessary to take a decision, the court was ready to take the decision in a quite expedient manner. In other words, there was some impression of coordination or harmonization of, on the one hand, the timing of the court's actions and decisions, and on the other hand, of actual needs or expectation of the political power. And finally, last but clearly not least, this was the problem of the contents of the judgment. Again, it was not easy to find a, let's say, legal logic in the lines of the case law of the court. It was easy to find that the final decisions in constitutional cases were very close to what was expected or awaited by the political branches of government since the beginning of 2017. The government did not lose a single important case before the court. So this all created a question. So exactly, is the court really independent or not? Because it's very difficult to assess whether individual judges are or are not independent subjectively, but of course we know that there is also this other dimension of independence or impartiality, namely the external assessment. What is the opinion of a reasonable external observer of the courts? If this opinion of an external observer is that the problem is impartiality or independence, it means something is wrong. It means that either judges can sell their independent opinions in a correct manner, or what is more probable, somehow unlucky of necessary qualities of independence. So this was a big question. A court, but what about independence and impartiality of this court? Finally, another question was what is a constitutional court? If you want to define the constitutional court, what is the mission? The formal answer would be to review constitutionality of laws, but it doesn't tell us anything. So we say, well, constitutional court is a court whose task is to protect constitution against the actions of political powers, against abuses. Let's say it's an insurance for a constitution being respected. Practice of the neo-constitutional court showed on several occasions that the real mission of the court is rather to protect political power from the constitution, and the constitution from the political power. Whenever it was necessary, the court proposed twisted and complicated interpretations. Okay, lawyers can explain everything, we know it. Simply think, yes, this is what the constitution requires, or what the constitution. This created a very, let's say, destructive picture of the constitutional court. This resulted in a severance of any form of cooperation between constitutional courts and the court and other courts of Poland. Other courts were under attack, and this also resulted in decisions taken on the European level, particularly by the European Court of Human Rights, that the constitutional court no longer meets the requirements of a court or tribunal under Article 6 of the Constitution. This all led to a question, mostly, of course, discussed in the academic circles. So what do we have in Poland? Do we have a constitutional court, or do we have some kind of a shadow body, neo-constitutional something which pretends to be a constitutional? But somehow, do we have a situation that the genuine constitutional courts required by the Constitution, somehow disappear, somehow dissolve in this abusive constitutionalism, and there is something new, some kind of a shadow imposter body which says, now we are constitutional. We have all these constitutional powers, this constitution grants to the constitutional. All right, as long as it was academic discussion, this was, of course, easy to discuss. Now, with the change of political context, last fall, the question was, so what about the constitutional court? This is, of course, a much more general question, which is typical for any transformation process, namely, to what extent, how to restore constitutionally required situation, or how to eliminate the situations that are clearly unconstitutional in a present time, but not using unconstitutional measures and not violating the Constitution on this occasion. Is it possible? Is it not possible? Or maybe, and this is another academic question, we can accept that in order to restore constitutionally required order, it is possible to apply some constitutionally dubious measures to eliminate the existing state of unconstitutional. This is, of course, very dangerous approach, because it could legitimate any type of authoritarian encroachment against the Constitution. But there is something in this question. So again, when this new context new political context. Something disappeared. Hello, are we connected?
Yes, yes, we can hear you.
Hello?
Yes, yes, we can hear you.
Something was maybe I said too much. But anyway, once this political context changed, so now it is a practical question. Because on the one hand, rather obvious that the Constitutional Court, as it is now, will not cooperate with the new government and will use all constitutionally provided powers to block any attempts of the new government to reconstruct the rest of the state machinery as well. So again, like 8 years ago, the question is, or rather the situation is that something has to be done with the Constitutional Court. And now we can see how close we are to this, let's say, a situation of a mirror. How not to act exactly in the same way our predecessors had acted 8 years ago, and now we are condemning them for it. It's a very difficult dilemma. In the discussions, as usual, there are two extreme positions and several intermediate positions. The revolutionist says, okay, this is an extreme situation. In this extreme situation, we have to apply extreme measures. The goal is a good one, so we will be excused, if not by the present constitution, but anyway by history and by God. Strict legalists said, oh, no, this is not possible. There is the constitution. We have to observe it. If something is wrong with the presence, we have to wait. We have to win another elections, and then once it is constitutionally possible, we should act, but nothing more. In the middle, there are different opinions. One of these opinions, which I must say I like personally, is exactly the question. So what are we talking about? Are we talking about the real Constitutional Court or a fake constitution? If this is a real, genuine constitutional, then I would support this legalistic approach. You must not touch. But if it is not a real Constitutional Court, but this is some imposter sitting in this, then there is more room for action. So maybe this is one of the ways how the situation can be addressed. Of course, not by academics, by politicians. What we see in the political side, we see a lot of a rather careful approach. Let's do something, but for a moment, there is only a resolution of the parliament, which claims that at least 3 persons are sitting illegally in the Constitutional Court, and drawing attention to the fact that, generally speaking, the decisions of the Constitutional Court may be problematic because of these problems with compositions and some other matters. Does it change anything? Probably it will not be easy to change the composition of the court because, well, the judges are elected by the parliament, so theoretically it's possible now to declare that these 3 judges are no longer judges and to appoint new judges, but then the president should take from any judge oath of office if he would not do. So this may not be particularly effective way. However, what could be effective is rather not to intervene directly into the court as such, but to intervene into the case of the court. Because now if the position, and this is also shared by many academics, is at least some judgments of the Constitutional Court have not been adopted in a constitutionally required manner. So it means the legal authority of the judgment is at the best problematic. Now, what does it mean practically? It means practically that those who apply those decisions, particularly the regular courts, now they have much more space to act, and this space to act means that they simply can disregard the judgments of the Constitutional Court. They can reinterpret those judgments. They can refuse to apply it. There is a lot of ways the courts, if they want, can do it, and then this is, let's say, life-saving role. This is still decision taken by a constitutionally established part of the state machinery, not by some politicians or by some academics who are preparing, let's say, a constitutional coup d'etat. Another life-saving role arrives from you. The Polish courts enough judgments of the European Court of Human Rights to say exactly the same. Decisions of the neo-constitutional court are problematic as to its legitimacy and legality. They could be disregarded, at least to the extent that they did not create individual entitlements claims or something like that. This may be a way. How it will be, I don't know. Whether the radical position, I see Wojtek Sadurski here, prevails or not. This is a good question, and we will see it in the future. But we can hope that sooner or later the Constitutional Court will be again a real court, not a Constitutional Court with very limited legitimacy, maybe no legitimacy. Very much.
Dear Professor, rather theoretical, I could say, yeah, because I really want to see how, for example, these fake constitutional judges and decisions as well, how to make them invalid in practice. I mean, yeah. So it's rather difficult question from practical point of view, but of course from theoretical, I think that it's one of the best solution in this case. But what I liked when you compare the main aim of Constitutional Court, namely not to protect constitution, but to protect political power from constitution. And I think that sometimes it looks like this, not only in Poland. I think that in many other countries, including Ukraine, there is a discussion if actually Constitutional Court is political, is political authority or not. Yeah, because of course it must protect constitution, but really in practice we see that sometimes it has really very political direction. Yeah, and of course it's a matter of justification of its decision. And of course when it comes to this proportion, for example, how to prevent the abuse of, for example, the abuse of rights by judges. I mean, the independence, this concept of independent judge, yeah, because sometimes we see that judges, they abuse their rights as well, and how actually to find this fair balance, it's also a question. And of course there will be also a question if does goal justify the means or not. In Ukraine, actually, we have very similar problems, and I think that it's really very important question, and it will be interesting and very useful to elaborate such decisions which could be applicable not only in theory but also in practice. But I think that we will return to this point during our discussion. So thank you very much. And we're going further. Our next speaker is Dr. Matthias Hartwig from Max Planck Institute for Comparative Public Law and International Law in Heidelberg. Dr. Matthias Hartwig was studied law in Erlangen, Aix-en-Provence, and Freiburg. He defended his PhD thesis in international law, and now, as I said, he's a researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. Dr. Hartwig worked also as an assistant at the Federal Constitutional Court of Germany and the Corte Costituzionale of Italy. He was lecturer at the University of Heidelberg, Saarbrücken, Trento, Santiago de Chile, Al-Farhabi University, University of Almaty, Universidad del Rosario in Bogota, Colombia, and in Hobart, Australia. Dr. Hartwig also has served as legal counsel at various constitutional courts in Eastern Europe, among others in Russia, Latvia, and since 1997 in Ukraine, counseling in and also he has published numerous publications in international law, European law, and constitutional law. And the title of his today's speech is The Ukrainian Constitutional Court and its Role in the Strengthening of the Rule of Law. So, dear doctor, you are very welcome.
Thank you very much for this warm welcome. I'm very pleased and specifically honored that I have the right to participate in this round of brilliant experts in order to contribute to the question of the role of constitutional courts, and I may say in difficult times. And here again, I would like to express my sympathy with Ukraine under the attack of Russia. And you may believe me that here the sympathy in Germany is with the Ukraine, exclusively with the Ukraine. And we do hope that you will overcome the difficulties you are facing at the very moment. I want to talk about the role of the Ukrainian Constitutional Court in strengthening the rule of law in Ukraine, and here in a way I can link up to what Professor Garlicki has said with the difficulties in Poland, because as you know, the situation in Ukraine was not always quite easy. The Constitutional Court was established in 1996, so more or less 5 years after the independence of Ukraine. It took some time to have a new constitution and took some time to establish this court. The idea was, in a way, to live up to the general European standards, because if you have a look around, all newly established democracy established and is still in constitutional court, which had the task and the function to defend the constitution against infringements by the other state powers. And at the same time, we have to underline that one of the functions of the constitutional courts is also, in a way, to cooperate specifically with the European Court of Human Rights, which has, as you may know, has its functions within the European Convention protecting human rights. And in order, in a way, to help this court, the constitutional courts of the different member states also have one of the main tasks of these courts is the protection of fundamental rights, in thereby helping the European Court in dealing with its tasks, because the national courts are in a way already filtering the cases which arrive at the European Court of Human Rights first, and secondly, in many cases they are able to settle disputes on fundamentals or human rights. The Ukrainian Constitutional Court had broad competences from the very beginning, among them also the interpretation of ordinary laws, which is not a common task of a constitutional court, and which has been limited, or not to say eliminated, in recent times. There was also one function which was not very often practiced. This was the decision on prejudicial questions by ordinary courts. I would say, unfortunately, the Ukrainian ordinary courts were not very willing or accustomed to lodge such prejudicial questions with the Ukrainian Constitutional Court. There was, if I may say so, there was a certain reluctance by the ordinary courts, which considered in a certain manner the Constitutional Court as a sort of a competitor, and therefore they were not that interested in getting involved in this interplay between constitutional adjudication and ordinary adjudication. Nevertheless, this competence still exists, and hopefully more and more ordinary courts will be willing to use this possibility to get an answer by the Constitutional Court on constitutional questions. One of the last, and I would say most important competencies added to the list of functions of the Ukrainian Constitutional Court is, of course, the individual constitutional complaint. By this procedure, the Constitutional Court can directly answer questions lodged by individuals. So there is this direct link of a citizens with the Constitutional Court. In a way, you may say this is the most let me say so, the most important function of the court to protect fundamental rights against infringements by state powers in order to protect the citizens. And therefore, it was generally highly welcomed that the Ukrainian court got this competence in 2017. It is still limited to checks of legislation. The Ukrainian Constitutional Court has not the broad competences like the German, for example, the German Constitutional Court, which is also empowered to review court decisions of ordinary courts. The Ukrainian courts is limited to the review of legislation. One particularity of this individual constitutional complaint in Ukraine is that this is not in the wording of the constitution and of the law on the Constitutional Court. It is not limited to the use of fundamental rights as the exclusive criteria, but it speaks of the compatibility of a law with the constitution. This is interesting because in most other legal orders, the constitutional complaint, or the only criteria to be used in the constitutional complaint, are the fundamental rights, not the whole constitutional frame. Therefore, in principle, the Constitutional Court may have, Ukrainian Constitutional Court may have a broader competence in the context of the constitutional complaint than other courts in Europe. And I just would like to mention the first individual constitutional complaint in 2017 decided by the Ukrainian Constitutional Court dealt with the questions of the prosecutor functions of the national authority against the corruption, the NABU, and here the Constitutional Court was dealing with questions of competencies in the realm of prosecution, criminal prosecution, which is not directly linked to fundamental rights. Therefore, we had already cases where the Ukrainian Constitutional Court played out its powers in the individual constitutional complaint, not limiting its parameters to the fundamental rights. Important decisions handed down by the Constitutional Court, I would like the most famous one, or the most important one, I would consider this is the abolishment of the death penalty in 1999. Thereby, in a way, bringing up the legal order of Ukraine to the general standards in Europe. It was a very important decision. It was welcomed by all other European states. More difficult, certainly, the question of the constitution, of the compatibility of the Rome Statute with the constitution, with the Ukrainian constitution. You remember in 2001, the Ukrainian Constitutional Court decided that the ratification, the law of ratification of the Rome Statute is not in line with the Ukrainian constitution, because there all adjudication according to the constitution is in the hands of Ukrainian courts, and it is not possible to transfer powers to the international court. This has consequences up to nowadays, as you know, because up to the moment, up to today, the Ukraine never ratified the Rome Statute, in spite of the fact that in 2016 there was an amendment to the constitution which opened the constitution to such a ratification. Ukraine recognized the powers of the court in the context of the war with Russia. However, there was never a formal ratification, and this is certainly one of the consequences of the decision of 2001 by the Ukrainian Constitutional Court. And I personally, I would really welcome sooner or later Ukraine could in a way use the powers now existing in the Ukrainian constitution to ratify the Rome Statutes. Other difficult decisions were, on the one hand, the decisions on the corruption legislation, the criminal corruption legislation of 2019. Here, the court saw incompatibilities with this legislation with regard to the assumption of innocence in the guaranteed by the Constitution, and therefore declared very important legislation in the fight against corruption incompatible with the Ukrainian Constitution. And you know, this had a very heavy reaction, specifically by the Western partners of Ukraine, which in 2016 insisted on the adoption of the respective legislation in order to effectively fight against corruption in Ukraine. The President Zelensky was so upset by these decisions that he wanted to dissolve the Ukrainian Constitutional Court and establish a new one with new judges. And here he was prevented by such an act by the Western European states. Another difficult decision certainly was a decision of the Ukrainian Constitutional Court in the case of the premature dissolution of the parliament in 2019. After the election of President Zelensky, the court decided in favor of snap elections in Ukraine, interpreting the Ukrainian constitution in a very difficult way, because I do not want to go into details. Perhaps you even know better than me what was at stake. I just would like to mention that it was difficult in a sense that the court did not strictly respect certain time limits established by the constitution. And therefore, at that time, there was some criticism of this decision, because it was seen as strengthening the position of the president, who wanted, with good reason, wanted to have a parliament with which he could cooperate. But on the other hand, after 2014, the role of the parliament was strengthened, and the role of the president was reduced or diminished in a way. And it was a little bit strange that now in 2019, the Constitutional Court gave in to the wishes of the president to have a parliament which was more or less conform to his own political political program. Difficult, of course, and this is the last part of my short lecture. Difficult, of course, was the permanent, one must say, permanent interference in the activities of the Constitutional Court by the executive. And this has unfortunately quite a long tradition in the Ukrainian history. Already Yushchenko dismissed two justices in 2008, and then again 2009, you know, Pshenichny and Stanik, and this was criticized by the Western partners. We had 2014, and this is very comparable to the today's situation in Poland. The parliament decided to dismiss the justices of the Constitutional Court elected by the parliament, so 6 of them, in order to have a new composition of the court more in line with the new idea of constitutionalism in Ukraine. Again, there was criticism from the West saying, you know, in a way, a Constitutional Court must be untouchable. Against other justices, criminal cases were pending, and they were never conducted to an end, with the result that these justices were under permanent pressure or risk or danger to be brought to criminal trials, and therefore they were in a way violated in their independence, because they were always running the risk to end up before a criminal court. Later on in 2019, the then president of the Constitutional Court, Shevchuk, was dismissed by his colleagues. Again, let me say so, an unusual measure by Constitutional Court to get rid of in a way of the president. You may also question the legality of this decision, because this was directed against Shevchuk as a president, not as a justice, and normally the justices do not have the didn't have the power to destitute a president of a Constitutional Court at that time. The case, as you know, ended up before the famous, if I may say so, Kiev District Court, which decided in favor of Shevchuk, again violating the constitution, because an administrative court cannot hand down a decision on a decision by the Constitutional Court. In the end, Shevchuk didn't return to the court, but it left a bad taste of the activities of this court. And the last case dealing with a with the question of interference in the activities of the court was the dismissal of the President Tupitsky by Zelinsky. Again, he blamed Tupitsky with illegal activities, with among other things having property in Crimea, which he hadn't declared. Nevertheless, there were no legal procedure respected, and therefore one may criticize his interference, even if Tupitsky had violated ethical rules to be respected by every constitutional justice. So these interferences certainly were problematic and have to be discussed and analyzed by constitutional lawyers in Ukraine. The reaction to all these events were, the legislation of last year, of 2023, which the legislation on the election of constitutional justices, when one must say under the pressure of Western states, procedure was established where in the pre-selection of the candidates to the posts of constitutional justices, a commission, advisory group of experts was established where Western experts for 6 years will have in a way, I may say, a decisive vote on who can be proposed as a constitutional justice. This is, in a way, interference in the Ukrainian sovereignty, and we may discuss this point. On the other hand, it had been considered to be necessary in order to get a composition of the court by really independent justices. So in the end, the legislation was adopted after a certain ping-ponging between the Ukrainian parliament and the Western states, but now it is it entered into force, this legislation, and in future, for the next 6 years at least, all justices to be appointed will have to be screened by this advisory group of experts, where, as I already said, the Western experts will have a casting vote, so to say. Certainly, the Ukrainian Constitutional Court will face further challenges, specifically in these times of war. Unfortunately, one of the next problems which might end up before the Constitutional Court is the questions if elections will have to be held in times of our presidential elections. There are different interpretations of the Constitution at the very moment. Unfortunately, the Ukrainian Constitution did not express itself on this point, and therefore there are different construction interpretations. And it may end up with the question might end up before the Ukrainian Constitutional Court, and this again will certainly a very difficult challenge of the court, because, as already Professor Garlicki mentioned, the question will be to what extent is this a legal question or a political question, and is there a risk that the Constitutional Court again will be torn into difficult political disputes, which could be a risk for its reputation. I will end here, and I'm looking forward to critical remarks and questions. Thank you very much.
Thank you very much, dear doctor. It was really very interesting to hear this consolidation of different facts. I would like to comment a little bit concerning the ratification of Rome Statute. Actually, we have supplemented the Constitution, and now there is no problem with this ratification, and we are going to ratify Rome Statute. Scientific community has already prepared even petition to ratify and somehow to influence on our political authority. But the question is that even if we ratify, there will be no, I mean, because Russia has not ratified Rome Statute, and probably we will need to create a special tribunal on the crime of aggression, because the ICC will not adjudicate this specific crime. That is why we will have a problem in the future. Anyway, concerning the constitutional decision of Constitutional Court on illegal enrichment, we have already also changed amendment the specific article of criminal court, and now I think that this article corresponds to Constitution. By the way, this, as far as I remember, specific this decision which was criticized by our international and I would say specifically German colleagues. This decision was prepared by Stanislav Shevchuk, ex-head of the Constitutional Court. So he was one of the main author of this decision, which was really highly criticized, especially in the context of combating corruption in Ukraine, because we all understand, of course, that there is a presumption of innocence, but maybe in case of Ukraine, and maybe if we want to combat corruption, we should create some stricter requirements concerning the public authorities, especially concerning judges. When it comes to ex-head Shevchuk, you know that there is he filed a lawsuit application to the European Court of Human Rights, and we are waiting for the final judgment of the European Court of Human Rights. And the problem was actually that he was dismissed not only from administrative post as a head of Constitutional Court, but he was dismissed by his colleagues, constitutional judges, from Constitutional Court. So this was the problem. How was it possible to actually dismiss a judge from Constitutional Court, not only from the position, administrative position of the head, but from Constitutional Court? And of course, there is a problem. And concerning our last ex-head of Constitutional Court, Tupitsky, actually, yeah, there was a problem that this decree issued by president actually it violated the very well-known general principle of law, such as lex retro non agit. So there was a problem that it was impossible anyway to dismiss judge from his post by canceling the previous decree issued, decree of adoption of this judge issued by previous president. So this decision was declared as illegal by the Supreme Court of Ukraine, and of course now we have a new head of Constitutional Court, and I hope that our Constitutional Court will be successful. And now I see that the reasoning part of decision is really very much, if we compare the judgment, previous case law, and now, I think that the reasoning part is really very, from scientific point of view, is quite persuasive. As for me, of course, we have to improve, especially when it comes to the number of cases adjudicated. It is quite low, unfortunately. Yeah, so we have problems. And the last point I would like to say, I sent the link to the advisory group of experts, because just a few days, several days ago, we started the first stage of a very new competition to the Constitutional Court with these international experts, with participation of international experts, and there are also 2 representatives from Poland in this advisory group. And now we have a stage on which the advisory group evaluate the moral qualities of judges. They even elaborated the methodology how to evaluate these moral qualities of judges, and it is quite interesting. You can watch these records on YouTube. There are online broadcasting, and there are not only in Ukrainian but also translation in English, and each interview lasts about 1 hour with each of candidates. So it's quite interesting to see how these moral qualities are evaluated. And I think that this experience maybe could be also useful somehow for Poland when it comes to the creation or elaboration of a new procedure, how to appoint judges. Maybe it could be also interesting to see and to apply this experience also. Okay, so thank you very much, and we are going further. Our next speaker is Marta Kłopocka-Jasińska, who holds a PhD in law degree and works as an assistant professor at the chair of constitutional law of the Faculty of Law, Administration and Economics of the University of Wrocław. She participated both as a leader and a member of research team in national and international projects, including constitutional complaint against judicial decision, the model suitable for Poland. Her main areas of research are human rights protection systems, comparative constitutional law, and the judiciary. She has given numerous lectures and courses at national and international level, and has carried out several research stays, in particular at the Complutense University of Madrid, Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Center for Political and Constitutional Studies in Madrid, the European Court of Human Rights, the Constitutional Court of Spain, and Constitutional Tribunal of Poland. And Marta is also a member of the Wrocław Bar Association. And she will deliver today a talk dedicated to the topic of constitutional complaint against judicial decision, a chance for the restart of the Polish Constitutional Tribunal. So, dear Marta, the floor is yours.
Well, thank you, Kristina. Good evening, everyone. First of all, I would like to thank you for invitation to participate in this seminar. It's a great honor for me and a great pleasure to be here and discuss such important topic as constitutional judiciary in Poland and Ukraine. Thank you also, Kristina, for introducing me. And of course, I must say that I do share the same feelings about solidarity with Ukraine, with Ukrainian nation as my colleagues from this panel. I will say that, as Kristina said, I had a chance to conduct research about constitutional complaint against judicial decision financed by the Polish National Center of Science. And the result of this research was the book, a monograph about this topic. And the purpose of the research was to establish whether and to what extent the Polish constitutional procedure about constitutional complaint requires revision. In 2014, when I began my comparative research about constitutional complaint against judicial ruling, I was convinced that the reform of the Polish model of constitutional complaint is required. The question was the extent of the reform and the chances for introducing it, because we must be aware of the fact that the current model of constitutional complaint is regulated in Poland by the Constitution, and in fact preserved in the Constitution in its Article 79. So changing this model therefore requires the constitutional amendment. So that time I have never expected the constitutional crisis in Poland and its consequences for the Polish Constitutional Tribunal. During the crisis, there was no good space to discuss equipping the tribunal with a new power, a power that could be used against those judges who tried to protect the values of the rule of law against the will of the political majority. Now it seems to be possible to return to the discussion on this topic. However, our main concern is the institutional weakness of the Polish Constitutional Tribunal, the lack of public trust in the tribunal, and the question how we can remedy this. So it is worth considering why such a crisis has occurred and how such a crisis can possibly be avoided in the future. So I thought that it's worth taking this opportunity to consider to what extent a constitutional complaint against a court decision can contribute to strengthening the weak constitutional tribunal. Comparative legal research shows that a constitutional complaint against a court decision significantly affects the way how the Constitutional Court operates. In my speech, I will first explain what a constitutional complaint against a court decision is and how it differs from the Polish model of constitutional complaint. Then I will talk about the advantages of such a complaint and the risks that are associated with such a model. And finally, I will address the question contained in the title of my presentation. Constitutional complaint is a remedy designed to protect constitutionally guaranteed rights and freedom. So it serves to protect individuals against violations caused by public authorities. Through the constitutional complaint procedure, individuals are thus given direct access to the Constitutional Court in order to vindicate their fundamental rights that they allege have been violated by the state. So individuals initiate the control procedure, shape the discourse by choosing which arguments to put forward in support of the claim that a violation of their fundamental rights has taken place. Generally, a constitutional complaint allows individuals to challenge a violation caused by ordinary courts or administrative authorities that have applied an incorrect interpretation of statutory provision. Such a complaint can be found, for example, in Germany, Czech Republic, and Spain. So less common is the complaint against the legislation itself, as basically a constitutional complaint against the lawmaker. That is that one that exists in Poland. The possibility of requesting that a law be reviewed by the way of constitutional complaint, it's an additional entitlement of the complainant, who is essentially complaining about an individual decision that violates his or her rights. So complaining about the law and eliminating of law by the decision of the Constitutional Tribunal via constitutional complaint procedure is treated rather as a measure of a last resort. However, in Poland, challenging a provision as unconstitutional is the essence of the constitutional complaint procedure. So it's a completely different model that exists in Germany, in Spain, or Czechia. So now, what are the advantages of constitutional complaint against the court decision? Well, first and foremost, the advantages are for the complainant. However, I will argue that also for the Constitutional Court. So the complainant receives a response from the Constitutional Court on the violation on his rights or freedom. So the major part of the court decision expressly states whether individual rights has been violated and in what way. The court, the Constitutional Court, has also the right to overturn the contested decision and return the case for reconsideration, so reopening the case before the ordinary court. And I think that this kind of judgment, this type of judgment, is much clearer to the complainant than the adjudication formula used by the Polish Constitutional Tribunal. So in such a model that exists in Germany, Czech Republic, and Spain, the complainant is affected directly by the decision of the Constitutional Court, and that decision directly changes its legal position. So I think that a constitutional complaint against the court decision make the Constitutional Court more likely to appear in the consciousness of the citizen as a body that protect their freedoms and rights. So this makes the court more visible for the individuals. I would say that this role becomes more visible for individuals. So thus, the court gains a chance to be perceived as a body that is on the side of the citizens, on the side of the individuals. So this result in it that the court is not mainly associated as a body restraining towards the parliament. So when I now look at the situation in Poland, I have the impression that the fact that the Polish Constitutional Tribunal was recognized as a fundamental obstacle to the legislative reforms, in fact, gave rise to the attack on the court by political power. What is more, I would say that probably Polish people learn about the existence of the Polish Constitutional Tribunal when the crisis started. And this is, in my opinion, a result of the Polish model of Constitutional Court. This is why I think that, and I would argue that maybe the reform of the model of constitutional complaint be a chance for the Polish Constitutional Tribunal for a new beginning. But of course, adding a new power is not enough here. So what are the risks with the constitutional complaint against the judicial decision? Well, let me be brief. So first, the backlog, and secondly, the potential conflict in the frame of the judicial branch. So a constitutional complaint against the court decision makes applicants more likely to benefit from this measure of protection. And this is proof by the experience of Germany, Spain, and the Czech Republic. A large numbers of complaints received by the court is its daily routine. So this causes problems with overloading the court. But what is the solution? Yeah, so this is why it is necessary to introduce some systematic measure that allow the court select constitutional complaint and make some changes in the procedure before the constitutional court. It is also necessary to properly shape the relationship between the courts and the Constitutional Tribunal, such a division of task, kind of division of task, because of course both the ordinary courts and the Constitutional Tribunal are supposed to be the guardians of the Constitution and fundamental rights, but the Constitutional Tribunal should be the ultimate guarantor. If the Constitutional Court can control the court's decision, then the conflicts over this may happen. However, this is also the matter of authority of the Constitutional Tribunal itself. I mean, in case of the strong constitutional court, which is endowed with the public trust, ignoring its ruling will not be profitable. To conclude, well, Monika, when inviting me to that seminar and proposing the topic, said that she hoped that this would give us a chance to talk about something else than the model for appointing constitutional judges. So unfortunately, I'm afraid that this topic cannot be avoided here. So the new model for the appointment of judges should be seen as a starting point for restoring the Constitutional Court. To be honest, I would be very cautious about giving the Constitutional Court a new competence that offer such a great potential for strengthening the Constitutional Court vis-a-vis ordinary courts. Before we say yes to constitutional complaint against a court decision, we need to ask ourselves what we expect of the Constitutional Court, what its role is to be in the constitutional system, and in particular, what its role is to be in relation to other courts. Do we want the Constitutional Court to be at the head of the judicial branch, or we prefer not to change anything in the way how the constitutional model and constitutional judiciary is organized in Poland? So the question from the title, yeah, shall the constitutional complaint against judicial ruling be a chance for the restart of the Polish Constitutional Tribunal? Well, I would say that the chance it is, but what the court needs is to rebuild its image as a guarantor of individual rights and freedoms. But how the court will use this measure is on the court. So other important element must be taken into consideration when we discussing the restoring Polish constitutional to its former glory. So I would say that for sure, pluralism and nomination procedure. I would even say that more women in the court and maybe a gender balance in the appointment procedure, it's a good solution. Secondly, the way the court communicates its decision. So for sure, arguments the court is using. and of course the way the court inform about its activity. I think that the good example of it is French Constitutional Council. The way how inform about its activities, it's a good example in my opinion. And of course, using the social media, it's another good option to improve the image of the Constitutional Tribunal. So what we need now is we need the court to be an important player in constitutional system with powers that allow him to be guarantor of the constitution and individual rights in the first century. So the restart should be a chance for something new, not just return what we had before. Thank you.
Thank you very much, dear Marta. I'm just thinking that I think that it really could be a very effective solution in case of Poland to implement such individual model, or if we could say, of constitutional complaint, because in Ukraine actually we have the same. We have normative constitutional complaint, and now we're also discussing some possible options maybe to somehow to make constitutional complaint be also possible to, for example, file a complaint not only against normative act but also against individual case decisions. Yeah, and in Ukraine, constitutional complaint, as far as I remember, was introduced in 2016. So still we really our experience is not so rich. Yeah, but I think that it's a good also instrument before applying, for example, even to European Court of Human Rights to try this institute. And I think that there is a really very good change and perspective for Poland, both for Poland and Ukraine, in elaborating this instrument. So we should just bear in mind that sometimes it is possible to find really practical and legal, simultaneously legal decisions. Okay. And we are going to our last but not least speaker, namely Dr. Volodymyr Venher. He is a Dean and Associate Professor of Constitutional Law of the Faculty of Law at National University of Kyiv-Mohyla Academy, former Deputy Head of the Secretariat of the Constitutional Court of Ukraine, and Head of the Secretariat of the Parliamentary Committee on Legal Policy and Justice. He holds a degree of PhD in law, conducts comprehensive research on theoretical foundations and practice of implementation of the rule of law and human rights standards in Ukraine, and his research activities are aimed at developing and substantiating methods for applying performance criteria for public authorities in various areas, such as provision of public services, organization and conduction of elections, judicial control over the protection of human rights. And dear Dr. Venher will deliver today a talk dedicated to the topic of the constitutional control of the quality of legislation, Ukrainian wartime experience. So, dear Volodymyr, you are very welcome.
Thank you so much. I hope you can hear me. And
yes,
first of all, thank you so much for your invitation and for this really huge honor to talk with such a respected speakers here. It's really a huge honor for me and really nice pleasure. And of course, thank you so much for good words and good wishes for Ukraine as a nation and for our people, from all speakers. I really appreciate that. And thank you so much from here, from Kyiv. Greetings from Kyiv. So talking at last place, it's huge responsibility, but at the same time, not to make you really tired. I will try to be as precise as possible, and I will try to present some ideas on constitutional court activities in Ukraine in wartime, but I will try to figure out key obstacles and some normative problems in constitutional court functions right now. So I won't explain all the powers, and thank you so much for Professor Hartwig presenting such a comprehensive and complex presentation on powers of the Constitutional Court of Ukraine. Right now, we can talk about two main blocks of powers. First one is traditional powers related to constitutional petition, which means an opportunity of special subjects to initiate constitutional adjudication on the quality of legislation. It's not purely parliamentary statutes, laws of Ukraine, but some acts of secondary legislation. And if we will take a look on that activities, all that activities almost stopped in 2020 after very famous but very negative judgment of the Constitutional Court on anti-corruption policies. And this is very, very serious institutional problem inside Constitutional Court, and that attempts from a President Zelensky and from a ruling political party and from a parliament and from law enforcement authorities to stop some of the activities of the Constitutional Court caused that even right now we don't have chairman of the Constitutional Court. We have deputy chairman who are acting chairman right now, and this is really, really complicated. So if we will take a look on the statistics of the judgments during wartime, we will see that in 2022, they issued only 13 decisions, and only 3 of them, they related to constitutional petitions. If you will take a look on a number of petitions, number of applications which are holding right now with Constitutional Court, we can see that one petition is still actual since 2014, 4 petitions from 2015, so, you know, and 17 petitions from 2020. I think the key problem is a lack of institutional capacity and trust from civil society and from constitutional experts to the activities of the Constitutional Court. And I really hope that these new amendments to legislation and new, it's not competition according to Ukrainian legislation, it's just a selection using some elements of the competition, which is taking place right now, will bring to Constitutional Court new five judges with a good reputation, with good quality and good competence. Another block of powers, it's really new competence delivered to Constitutional Court, it's constitutional complaint. And in 2016, we received amendments to the Constitution. It's really new tool for human rights protection according to Ukrainian constitutional adjudication. But this new tool started only in late 2017 because of the lack of proper legislation and lack of secondary legislation regulations for that issues. So honestly, only in early 2018, we received first attempts to apply with constitutional complaints to Constitutional Court. And it's really hard to analyze all the peculiarities right now because in 2020, 2020 in Ukraine, as in other European countries, we received COVID-19 limitations and its, of course, influence on the activities, of course, legal activities. Too, of course, in 2022, full-scale aggression started. So I think it's too early to talk about the efficiency of the constitutional complaint in Ukraine, but we can have some interim results. And here I will present two big problems with constitutional complaints in Ukrainian reality and Ukrainian legal system. First of all, I should talk about. I should tell you about influence on a legislation. As colleagues mentioned here, in Ukraine we have normative model of constitutional complaint. What does it mean from practical point of view? Only after using all possible tools to have your case in ordinary course, after final decision, which is in force in ordinary courts, a person, a subject, private person, of course, and some private legal entities, no public authorities are allowed to apply to Constitutional Court with constitutional complaint. So they can apply to Constitutional Court and demand to review the quality of the provisions of legislation, parliamentary statutes, which have been applied by ordinary courts in their case. It's extremely important that we have this combination, like final stage of judicial proceedings in ordinary courts and application to review the quality of the legislation. From this perspective, of course, the results of the constitutional adjudication should be some reaction from the parliament to correct the regulation in a proper manner. And if we will take a look on key ideas from constitutional complaints, what are the key subjects to apply to Constitutional Court? We will see, first of all, it's social payments, social protection, of course, it's employment issues. And during 2023, we can see a huge number, big number of criminal procedure cases. These cases related to relevant legislation on detention issues, on other preventive measures applied by the law enforcement authorities according to relevant legislation, etc., etc. But if we will take a look on statistics, it's really huge numbers from Ukrainian perspective, of course. For example, in 2023, we received a little bit more than 400 constitutional complaints to Constitutional Court. It's not official counting. I hope in the nearest weeks we will receive official report from Constitutional Court, but it's a little bit more than 400, like 416 or something like that. But we can count how many cases were accepted by the Constitutional Court. So only 143 cases people received refusal on opening constitutional procedure, and only 47 cases were positive at opening of the constitutional procedure. And all other applications were sent to the applicants without positive results to start constitutional proceedings, which means that quality of that constitutional complaint and readiness of Ukrainian legal system, first of all, attorneys who are supposed to apply and to represent people, they're not really ready to do that. But key problem here is reaction of the parliament, reaction of the legislators, because having this normative normative structure, the constitutional complaint, it's extremely important to have judgments of the Constitutional Court enforced, which means Parliament should adopt proper changes to Ukrainian legislation. If we will take a look on a official report from Constitutional Court from 2022, they analyzed at that time all their 13 decisions, and only in 4 cases Parliament adopted some changes, but very, very occasionally. And Constitutional Court even cited that new pieces of legislation and ignored doing a conclusion. Is it in a correspondence with their judgments or not? Because in almost all that cases, it was only partial enforcement of the ideas from Constitutional Court positions. How does react Constitutional Court on that activities? And we can take a look on the last decisions, both as a result of constitutional complaints and constitutional petitions. So we can see that it's extremely popular right now to postpone acting on the judgments of the Constitutional Court. So it's a little bit ridiculous from a legal perspective when you have judgments of the Constitutional Court where you have a decision that some provisions of the legislation are unconstitutional, but at the same time you have 3 months or 6 months postponement of enforcement of such a decision. It's not only about social payments or something like that. For example, in a last decision which have been issued on November 1st, 2023, the Constitutional Court decided not to enforce their judgment as soon as possible because the problem was with some customs and some taxation issues, and enforcement without proper reaction from a parliament amending proper legislation could cause lack of regulations of legal responsibility in some fields. The same situation we have with social payments. Very often having unconstitutional provisions of different pieces of legislation means that Ministry of Social Protection just without proper parliamentary regulations stay on a position that they are not obliged to pay any kind of social payments for vulnerable groups. From this perspective, we can see an attempt from Constitutional Court to act more actively, not only as a negative legislator, but as a positive legislator. So they are trying to influence on a parliament, given this, we can say, vacation or some additional term to think about and to take care of these activities. What is the influence of martial law on that situation, on that peculiarities? Of course, we can say that Parliament is a little bit overloaded. Parliament is in a very dangerous situation. But if we will go through all 12 judgments issued during 2023, no one from that list received the proper attention from a legislator. And I think from, of course, legal point of view, it's not an excuse for a parliament, because for a majority of their judgments, it doesn't need proper huge legislative changes. It's very minor changes, but it's general attitude from a legislator to Constitutional Court and constitutional adjudication at all. And I think this is the same problem with the lack of trust and problems with institutional capacity inside Constitutional Court. And second problem, which is extremely urgent right now, It's a cooperation or collaboration in normative way between Constitutional Court and Supreme Court of Ukraine. Talking about normative nature of the constitutional complaint, if a person, if applicant receive positive decision from a constitutional court, according to procedural legislation, he or she can apply to Supreme Court and request additional proceedings on his or her case. And in this situation, we have extremely weird position from Ukrainian Supreme Court. They just ignore the nature of the Constitutional Court judgments. So they reopen proceedings in cases, but they refuse to apply the Constitutional Court's position to the case because of the prohibition of retroactive enforcement of the judgments of the Constitutional Court. Of course, we have such a positions and such a practice in other constitutional courts and in other legal systems. But talking about Ukrainian experience and these very, very fresh and new attempts, I can say endeavors from a legal system to use constitutional complaint as a tool to protect individual rights, it diminished everything. It abolished all attempts to introduce these tools. Moreover, in this way, Supreme Court ignores Article 55 of the Constitution of Ukraine, where constitutional complaint is named in a list between all other judicial tools for human rights protection. From this perspective, it's not just occasional position. We have a lot of judgments from Supreme Court, moreover from Grand Chamber, from Supreme Court, where they refuse to apply these retroactive enforcement to individual case. From that perspective, it's really important to say that lack of proper reasoning, both in Supreme Court judgments and in Constitutional Court judgments, causes, from my personal perspective, inefficiency of constitutional complaint at all, because it converts it to a very positive, but at the same time not meaningful tool to protect individual rights. It became a tool to correct national legal system or to provide some positive achievements for future decisions or for future cases, but not for initiator's case. From that perspective, we can say that it should be analyzed, of course, from more complex perspective. And Constitutional Court's position is that there is no proper solution for such a problem without complex amendments to the Constitution of Ukraine, which is also not really argued from my personal perspective, because I think Constitutional Court of Ukraine has enough powers to interpret in other cases, in next cases, this situation, and to rule for a Supreme Court to take into account these peculiarities and this nature of Article 55 of the Constitution. Just to sum up, these two main problems in wartime, they cause not really normative perception and these special peculiarities for relevant branches of the legislation and relevant pieces of legislation. We can see that Ukrainian Constitutional Court is still in a huge danger and huge political influence. And here we already heard today about initiative to apply for a constitutional court to have interpretation of the constitutional provisions on a possibility holding elections, presidential elections during martial law. So I think this is another really huge threat and challenge to have additional problems with the trust to constitutional court, to have additional attempts to have political influence of the constitutional court. And these threats, they cause lack of proper attention to very legal issues, to very I can say legal routine issues for national legal system, and lack of trust and really huge concentration on political or policy issues by the Constitutional Court of Ukraine can cause total ignorance and lack of trust, not only to judgments, which are right now much better from the quality and way of reasoning than a few years ago. But anyway, lack of trust can cause abolishment of their influence on a national legal system and taking care of the human rights protection, which is huge problem, and I can say disaster for a country in civil law system to which Ukraine belongs. So thank you again for inviting me to present these brief ideas, and I will be happy to answer a question or participate in discussion later. Thank you so much.
Thank you very much, dear Volodymyr. Yeah, it was really very interesting, your considerations. I think that the main challenge for a constitutional court really when it comes to martial law is to become really a guarantor of human rights. Yeah, because under the veil of martial law, there could be possible different, I would say, abuses from public authorities when it comes to separation of powers, especially the emphasis on executive powers under the veil of martial law, and of course the limited restrictions of human rights, again because of war. And yeah, there is a really very big concern if constitutional court will be really very consistent and strong in this case. And I think that we will see it in the future. Now I can't say that there is really many constitutional complaints against restrictions of human rights because of war, but I agree that the number of cases adjudicated and the number of constitutional complaints considered by Constitutional Court is really very low. And of course there is a problem of quality of this constitutional complaint applied to Constitutional Court, because I completely agree with Volodymyr that there is a problem in definition of subject matter of constitutional complaint in Ukrainian society, and we need probably more skilled lawyers in case of proper preparation and definition of subject matter of constitutional complaint, because really the majority of them, they are simply rejected because of violation of some not maybe merits, not formal, but also merits of while preparing these constitutional complaints. And of course, I agree that we have really very big problem with enforcement of constitutional court decisions. But I think that it's impossible to create some legal tools to enforce our public authorities to implement these judgments, because it's more about political culture. Yeah, and probably we need time, because it's not possible to consider everything. Yeah, sometimes we need this political culture. And of course I agree that there is a question when it comes to the definition of determination of the constitutional, when the the constitutional court's acts start to act. Ex tunc from the beginning, ex nunc from now, yeah, and pro futuro to the future. But I think that it's also scientific. It's a case for a scientific discussion. But I just don't want to prolong my speech, and I will give the floor to my brilliant colleague Monika for moderation of discussion. Thank you very much.
Thank you very much, Kristina, and thank you very much also from my side to all the speakers for the very interesting and inspiring contribution. I think we can summarize these 4 speeches by saying that the Polish and Ukrainian constitutional courts are currently at a particular point in the history. Even we can say the Polish Constitutional Court is in a deep crisis. It needs a thorough reform. Basically, it needs to be built from scratch. However, this reform is still ahead of us. In Ukraine, on the other hand, the situation is maybe a little bit better, as the reform of the Ukraine Constitutional Court has already started. And as it was mentioned by Kristina, even today we can observe the process of electing new judges to the Ukrainian Constitutional Court. So now I would like to open the discussion, and I would like to invite you, all the participants of our seminar, to share their questions, comments, and doubts. We have, I think, around 20 minutes for discussion. If you would like to contribute to our discussion, please raise your virtual hand. I think it's the best option. And I'm already seeing the first submission to the discussion, which I'm delighted about. So I would like to invite the first discussant. I think it was Professor Wojciech Sadurski. So please, Professor, it's great to see you. And please take the floor. We are not able to hear you, so please unmute.
Yes, of course.
Right.
So thank you very much. Thank you very much for having me here as part of the audience. Before I ask my question addressed to Professor Garlicki, who has just disappeared from the screen, but I hope he will be back in a moment. I just would like to say a few personal words. First of all, I would like to express my very deep solidarity with all the Ukrainian colleagues and friends in this dramatic, tragic moment. I myself, if I may add that, I had been connected with Volodymyr's law school years ago. I was a visitor and advisor on behalf of the Open Society Institutes. I spent twice a month stay each, looking at your Kyiv Malchila Academy's law school, being very, very much impressed, and I hope very much to revisit it. I was already, after the outburst of the war, twice in Ukraine, but both times Lviv, meeting my law friends here. I've been planning to go to Kiev soon. This time I had to postpone it for health reasons, but I'm planning to be at the end of the year. So one day I may knock at your door, Dean Venher, and have a chat. But thank you. Now let me go back to Professor Garlicki's introductory lecture. So I think that you have put the sort of fingers on the right essence of the issue, saying, considering these two, if you like, possible approaches to the repair or change of the Constitutional Tribunal, a radical one and a much more moderate legalistic one, that it all depends on whether we consider Constitutional Court as it parades itself to be as a fake court, as not a real court, in which case probably a radical solution of drawing practical conclusions from it would be justified, or whether we have a different account of what's going on with the court. Probably everyone will agree that it's damaged, but it still exists. And my question is, we lawyers, we can, or scholars can continue talking like that, but politicians have to choose. They cannot give a conditional answer. If it is this, then that. If it is that, then this. No, that we need to have some statement, some assertion of whether we are dealing with a damaged court or whether we are dealing with a sham court, with something that just presents a facade. And you know my position, but I'm interested in your view, and also in your view about the following statement that these days actually restoring Constitutional Tribunal to its operation is perhaps not all that important, because we have a growing hope in ordinary judges conducting dispersed review. And this is one of the conclusions which you draw in your brilliant chapter, which you co-authored with your collaborator, when you say that one of the outcomes of the crisis in Poland may be the spreading and the legitimation, if I may put it so, of a decentralized, dispersed model of concrete review run by regular judges. Thank you.
Thank you very much, Professor. As we are short of time, I would like to propose that we collect the questions, and then at the end of the meeting, I will give the floor to the speakers just to react to all the questions. So we have also the other person that would like to submit the question, and I would like to give the floor to Andreev. So please take the floor.
Thank you. First of all, I would like to express my many thanks for organizing such a great event and for participating and for your great presentations. And I would like to ask 3 questions. The first 2 will be to the first speaker, and I would like to deepen the first asker, the first person who asked questions. So what should we do with this constitutional legacy for this period of time? And should it be a legal decision by the Constitutional Tribunal itself, or should it be a parliamentary decision which disregard or stops these decisions in force? And the second question is about the judges themselves. So what should we do with their privileges? Should they be allowed to hold the title of the Constitutional Tribunal judge, or should they be left without it and without any financial payments from the government in the future? And one question to Professor Venher from Kiev Hill Academy. You pointed out the current selection procedure for the judges of the Constitutional Court of Ukraine. And I remember my times when I worked at the Ministry of Justice of Ukraine, when one department asked us about a legal position on amendments to the law. And I wrote that the amendments which were proposed by one deputy were not in line with the Venice Commission recommendations. And my supervisor said that the decision is already taken, and it's okay to write that it is in line with European recommendations and everything with them okay. It was a question with the composition of the advisory board for selection of judges. So if we see such political unwillingness to follow all the recommendations which are made by European partners, are you optimistic or pessimistic about the results of really good judges with high moral and professional qualities, which will ensure that the constitutional justice in Ukraine will develop in the right direction and will bring us closer to the European values and European community, and not in another way, that the Constitutional Court of Ukraine will be again criticized for its passiveness, for its unwillingness to make its constitutional moment, to proclaim itself as an independent branch of power with its own functions and with its own word, which is not sensitive to the current political needs. Thank you very much.
Thank you very much. And if you agree at it, maybe I will explain also to the participants of our seminar that among our participants that there are also students from the Jagiellonian University and from the National Law University in Kharkiv that are our collaborators, young collaborators in our project, and it is one of those students. So thank you very much for joining. Thank you for your questions. So we have already 4 questions, and I'd like to ask the other participants if we have any other questions. I've got at least one additional questions that I would like to. Oh, yeah. So maybe Dr. Hartwig, please take the floor. But please try to unmute. Oh, thank you.
So, sorry, if there are other questions, I will take back my question because I already had some time to talk. I just would. Are there other questions?
No, at this moment, not. So that's why your questions are welcome.
Just three short remarks. Marta, if I may say so. In Germany, it took 3/4 of a century until we had a majority of women at the Constitutional Court. Sometimes, things take time. Volodymyr, I would raise a question to you, dealing with the question of the criteria for the individual constitutional complaint in Ukraine. Is it in the law? It said the law must be incompatible with the constitution, or is it in the context of the individual constitutional complaint necessary that the only criteria to be applied by the court will be the fundamental rights? This is a difference. There's a difference, and I tried to explain it with the first example of a constitutional complaint decided by the Ukrainian Constitutional Court when they dealt with the question of the distribution of powers, dealing with the prosecution, criminal prosecution in Ukraine, which is not a fundamental right, but it was decided in the context of a fundamental right of an individual constitutional complaint. So there is some unclarity to me. Marta. 3 points. I completely agree with all what you said. You could make your case in a way even stronger with 3 points. First of all, of course, the presence of a court depends also on the number of the decisions. And if there is a possibility to criticize also ordinary court decisions, there will be much more decisions. The German, with regard to Germany, I would say 90% of all decisions of the German Constitutional Court deal with ordinary court decisions. This first point. The second point is, whenever you criticize a law, you can interpret it in line with the Constitution or against the Constitution. You know, you can say this law is constitutional, but only if you decide it in this sense. But if you admit such an interpretation in conformity with the Constitution, you make the first step in reviewing individual ordinary court decisions. This is a very important point. So if you say, you know, this law which is under review is in line only insofar as it is interpreted in this sense or the other sense, then you interfere with the interpretation by ordinary courts. And the last point which has to be made is the relationship with the European Court of Human Rights. I think it is a very important task of the national constitutional courts, to help the European Court of Human Rights to cope with this workload. And if there is an effective national constitutional court, it can, of course, diminish the workload of the constitutional court. I can give the example of Germany. There are much less cases against Germany before the European Court because we have our very effective constitutional court. And I think this is one of the main tasks of the national courts in the European frame. And once you admit the review of ordinary court cases by the European Court of Human Rights, there is no argument to say, but the National Constitutional Court shall not have this competence. This would be a contradiction. And therefore, I think you should add this European dimension to your argumentation. Thank you very much.
Thank you very much. At least for this moment, I do not see any other questions, so maybe I will add one additional question. And it will be a question to Professor Garlicki and to Dr. Hartwig. I'd like to ask whether it is possible to imagine, because this is the question which is quite often in the Polish discussion as well. But I'd like to see how you could react. Also, maybe Volodymyr, it's also for you. So, whether it is possible to imagine the functioning of the Polish state, of the Ukrainian state, without a constitutional court, and if so, how the review of the constitutionality of law could be carried out, or whether, in particular, the Supreme Court in each of the country, in Poland, in Ukraine, could take over the competences of the Constitutional Court. Dr. Hartwig mentioned about and Volodymyr, I think he mentioned about the relations between the Constitutional Court and the Supreme Court. Yeah, but the question is whether the Supreme Court could take the competences of the Constitutional Court, and maybe we could think in such a way that it's no way to reform the court, but just maybe the other better institutions will be enough to exercise the constitutionality of law. Okay, so if there are no other questions, I know it's very late, so I would like to go and now to firstly, I think, to Professor Garlicki. I hope that Professor Garlicki is still with us.
I am.
Yes, great, because you are on the second floor. So, Professor, please take the floor.
Well, thank you very much for this remarks. And well, Professor Sadurski was kind enough to recall my, let's say, more general position. Namely, do we need a constitutional court at all? At least in the Polish context, I must say, I'm not sure. I can easily imagine a life without a constitutional court, not because I'm against the Keynesian concept of a centralized judicial review as such, but the developments in Poland demonstrated that whereas a constitutional court may be a very useful institution, let's say, when the weather is nice, it has less possibilities to fight when it is under attack. This is a small body. This is a body where judges are appointed for a limited period of time. This is not a body which has a backup of thousands of judges, like this is the case with the Supreme Court. So without even trying to formulate some, let's say, theoretical assessment, my impression after the 8 years of the Polish crisis is that the Constitutional Court, its very brave and courageous resistance notwithstanding in the first period of time, still was easier to be captured, politically captured, than the Supreme Court, or even more the remaining court. This created certain situation. Maybe it's a specific one, maybe it's untypical one, maybe it does not fit to the general theory that Keynesian is better for Europe than the US courts. I don't know, but in the present situation, again, I can imagine that the Constitutional Court disappears. And its functions are taken by regular. But then the question is, what does it mean disappears? There's only one way, constitutional amendments, but this is theory. This is not possible, at least in the foreseeable future. So probably the only way is somehow to detour the Constitutional Court into some kind of a desert or another nice place to live, but simply convince the other court that it is not necessary to always have always take into account the judgment of the Constitutional Court, to ask the Constitutional Court for decisions, etc., etc. Again, it seems that these 8 years somehow convinced other courts that it is possible, that the courts could easily function on themselves, either by steering constitutional cases, or rather either by, let's say, transforming constitutional cases into cases based on EU law or European Convention on Human Rights, and getting decisions from somewhere else, or to decide independently, just independently applying the Constitution to several cases. Probably this plus general already 20 years of training of the courts in application of EU law has sometime taught courts that review of compatibility of parliamentary statutes with higher law is not so difficult and not so impossible. So this, of course, would be not an ideal situation, because still the Constitutional Court would be there and would be around, but unless it is radically changed and reached, there's probably no other way to deal with. This is also not an ideal situation because well, we are very optimistic as far as the other courts are concerned, but you also have to see that, for example, in the Supreme Court, this is not so easy. There are good chambers and there are not good chambers. So again, the process of destruction of corruption, particularly of the Supreme Court, is also well advanced. And this will not be easy to undo, just because probably in respect to courts, I would be very, very difficult, very careful in any proceedings of radical changes or firing judges, etc. But again, this I can imagine. I don't think it would be a good idea, moving to Monika's comment that this should be just as a new chamber in the Supreme Court, because yes, right, this will be just a change of names, and we already have some new chambers in the Supreme Court, so this is not a very good idea. No, this should be simply the procedure allowing each and every court to disregard statutory provision if, clearly, obviously, whatever we say, if unconstitutional. Of course, we should not have too many illusions. This is still the civil law judicial system. So anyway, the Supreme Court and the Supreme Administrative Court probably would always have a last say in important matters, unless they will not be ready to do it. Whether it would work, I don't know. Whether it would remove the problem we have now without killing of the Constitutional Court, maybe yes, because moving to the question of Andrew Tate, well, but who should do the killing of the Constitutional Court? And then I must say it's difficult because, again, we can do it easily in academic discussion. Okay, it does not exist. It's a fake court. But as Wojtek Sadowski said, but now there must be a decision. If this decision is taken in any other way than constitutional amendments, it will be always possible to challenge. And it will be always possible to say this is all unconstitutional, probably not without a lot of effort for such. So that's why bypass constitutional court is maybe more practical or more pragmatically justified than abolishing or destroying the court as such. Had it been possible to change the composition of it, then fine. But as long as it is not possible, I mean, in the pragmatic point of view, then we may have problems with this approach. Again, once the courts are they get a blessing, yes, you can disregard the decision of the Constitutional Court. This is more or less what the European Court of Human Rights declared, at least in 2 or 3 cases, starting from Xero Florence and the ML case in abortion. Very recent. Then it may encourage the regular judges. What would be very important, and this is still a missing point, it would be a clear position of the EU, the ECJ, as far as EU law is concerned. This is an impressive case law, of course, on the Supreme Court. There is less room for the ECJ to decide on the Constitutional Court, and keeping in mind the authority of EU law and its interpretation in regular courts, this also could be very important. And finally, what should happen to the current debt? Well, we may kill the court. We need not probably to kill judges, at least too many judges. I would say, well, any precedents of taking pensions or other benefits from persons who already have functioned for a long time is very risky. What I can imagine, however, is some set of disciplinary proceedings, at least against some current judges of the Constitutional Court. For example, if a judge who was a member of Parliament and who has publicly presented his or her position in several legislative debates, now sits in the court and decides on the constitutionality of the same statute. This is violation of what is clearly written in the Constitutional Court Act even today. And then, in my opinion, this is a disciplinary fault of both the president who appointed and the judge who did not request being disqualified from the This could help maybe the state budget not to pay all benefits to all former judges forever. But here I would be very careful, and just a very brief remark about the Polish constitutional complaint. Of course, it is not perfect. Why? Because this was a compromise. The text of the Polish constitution, it was created because of the born out of the compromise between the Constitutional Court and the Supreme Court, and the strong personality of Professor Strzembosz somehow prevailed. So constitutional complaint is as it is now. There was no, let's say, academic wisdom behind this decision. It was just a political decision within the constitutional committee, and the constitutional court was not very unhappy. We're all afraid that we will have too much to do. Thank you.
Thank you very much, Professor. And now I'd like to give the floor to the second speaker, Dr. Hartwig. Okay.
Yeah, thank you very much. Very briefly, answer your question. There is no must of a constitutional court. There are states which have the respect the rule of law without a constitutional court. Just think of Great Britain. They have now a Supreme Court, but it's not a real constitutional court. In France, the Conseil Constitutionnel, it's not a real constitutional court. The Supreme Court is a mixed court. So there are states, Australia, a fantastic legal system without a constitutional court. So there are states which have respect the rule of law without having a constitutional court. This is the first thing to be said. The second question is of course, what does it mean to abolish a constitutional court? We had the discussion with Hungary. Once you establish it, it is difficult to take it down. And Hungary in 2010 was harshly criticized for diminishing the competencies of the Constitutional Court. And I think would say for a good reason. What does it mean? It means having a constitutional court is, so to say, a further step in the guarantees of fundamental rights and of the constitutional order. Therefore, there is a good reason to say, the constitutional court adds to the rule of law. Of course, we can always say other courts can take over the competency to protect fundamental rights. In Germany, every court has to protect the fundamental rights, not only the constitutional court. But it is always something special if you have a constitutional court, because it is only focusing on fundamental rights in this context. And this is much more effective than having a civil court, for example, which applies a civil code and, among other things, the constitution. In Germany, it has changed a lot. In Germany, would have a different legal order without the constitutional court. This is for sure. This is for sure. This is a German experience. I must tell you, plenty of examples where the constitutional court stepped in and changed our legal development after the Second World War. It was very important. And the last argument, which I already produced, is the question of the interplay between the constitutional courts and specifically the European Court of Human Rights. Here, I think the European Court of Human Rights would be killed by the workload if there were no national constitutional courts which should decide the main cases. And only once filtered by the national courts, the cases should arrive at the Constitutional Court at the European Court of Human Rights. And this sense, it has a practical function, the national constitutional courts. Therefore, you hear it, I'm completely in favor of a national constitutional court, even if it's not directly required by the rule of law. Thank you very much.
Thank you very much. And Volodymyr, would you like to react? Also for my question concerning the Ukraine Constitutional Court.
Yeah, thank you so much. I have 3 questions, and I'll try to be precise as it could be. So first one about competition and transparency. In Ukraine, we have second, we can say, competition for top level judiciary authorities for a last decade. So first one, we had competition to Supreme Court in 2016, 2017, which was, we had discussions, is it okay? Almost the same discussions like in Poland right now on Constitutional Tribunal, because, we abolished the previous version of the Supreme Court of Ukraine, and we introduced new Supreme Court without word Ukraine, which ridiculous, but anyway, but it was a formal reason to restart, and that competition was extremely open, transparent. Of course, we had some problems, but as a result, the composition is much better than previous one. Of course, with some problems. So right now, the level of transparency even much higher then in that competition, we have all online live broadcasting for interviews with candidates, and some interviews are really ridiculous. Of course, this advisory authority, which is developed, including international experts, it's not the best reason, because anyway, discretion to appoint or not to appoint, it belongs to official authorities, for president, parliament, and assembly of judges. But at the same time, I do hope, and in Ukraine we do hope, that this extremely high level of transparency will provide additional responsibility and additional trust to results. We don't have any other tools. We don't have any other, formal influence. And I hope that in martial law, under this huge threat from war and from military aggression, it will help us to figure out appropriate candidates, and we will fill these 5 vacancies in a proper way. Second question was from Dr. Hartwig about fundamental rights. Talking formally from precise wording from Ukrainian legislation, if we will take a look on a law on constitutional court, we will see that person who is applying with constitutional complaint should argue not only about breaching or limiting fundamental rights, but all rights guaranteed by the Constitution. So, but at the same time, in Ukrainian Constitution, we have traditional provision that rights in constitutions are not limited. So it's not really easy, but I think, and I do hope, that according to this concept, we should take care on a little bit wider list of rights according to Constitution. And the key problem here is that we still do constitutional adjudication to the quality of legislation, but not aiming to protect human rights, and all that problems I mentioned, I think, would prove that. So yeah, it's very good and urgent question, but it needs more exploration and maybe additional arguments. And last, about constitutionality. We had this discussion in 2015, 2016, to what extent ordinary courts in civil law system, according to Kelsian model, can act as a protectors, as authorities who take care of the constitutionality. We didn't receive like stable position for all constitutional law lawyers, but we reached one very small but very, very important point in that discussion. During amendments to procedural courts, all procedural courts, criminal procedure court, administrative procedure court, and civil procedure court, before 2017, all ordinary courts of first instance, appeal instance, and even cassation instance, third instance, if they face any problems with constitutionality of the legislation, they had power to stop proceedings and apply to the Supreme Court, which should apply to the Constitutional Court. After amendments of 2017 to procedural legislation, we have not really clear and not really strict, but anyway, obligation for any judge in ordinary court to apply direct provisions of the Constitution, and the power not to stop proceedings, just to provide judgment, having this direct feeling of the spirit of the Constitution, and to use concept contra legem, and of course it's not decentralized model as in US or other common law system, but I think it's very good step ahead. Right now we don't have like complex analysis of the case law, but I think it will be extremely interesting. We have some cases where judges are so brave, so strong to to act against formal legislation, against secondary legislation, and apply constitution directly, even without applying to the Supreme Court and to Constitutional Court as a result. So from my perspective, we should rely a little bit more on ordinary courts in protecting constitution, because having these wartime challenges, for example, in Ukraine, and extraordinary challenges like COVID limitations in Europe or all over the world, it's impossible to rely on a constitutional adjudication provided by a special authority in all cases. And, in Ukraine, we very often discuss to what extent even legislator is supposed to react on recent, for example, wartime challenges. And very often we can see a lot of examples where people are acting according to natural feeling of justice, even without proper legislation. For example, I don't know, punishing people, robbers, or burglar, or any other wrongdoings, we can say, during martial law. So from my perspective, these, just to continue a discussion between Professor Sadurski and Professor Garlicki, I think these, constitutional borrowing, or like unification of the approaches between common law system and civil law system, right now it's extremely important, and we should borrow the best practices and use efficient tools. Sorry for talking too much. Thank you so much.
Thank you very much, Volodymyr. And last but not least, Marta, the floor is yours.
Okay, thank you, Monika. Well, I should say that I'm very preoccupied that it took 3 decades in the German Federal Constitutional Court to have women there in such a number, as Matthias said. I would say that I would prefer waiting not too much time for it. But to, what should I say, more about what Matthias said. Well, I agree with him that the constitutional complaint against judicial decision provokes a large number of individual applications, and we discuss about thousands, not 100, but thousands, yeah, and this require a reform and a modification of the admissibility proceeding, and we can see such a reform before German Constitutional Court and also Spanish Constitutional Court. However, the concept of the complaint as a measure to recompensate a violation of individual rights have not changed. So still individuals may seek protection, and they receive the answer about the specific violation of their rights and freedom. In case of Polish constitutional complaint, the decision is rather about conformity of law to the constitution, not about the specific violation of individual rights. To address the issue of the dialogue or interplay between Constitutional Tribunal and the European Court of Human Rights. Well, I would say that there are some opinions that the broadened model of constitutional complaint, it's a kind of remedy for the overloading of the European Court of Human Rights. That means that if in the legal system exists such a broad legal remedy that allow or that makes that the lower number of individual application are lodged to the European Court of Human Rights. However, I would also say that about this interplay, So in my opinion, the constitutional courts are the natural partner for a dialogue with the European Court of Human Rights. So here they may discuss the most important issue of individual rights and freedom. So from my point of view, I agree that this is the role of national constitutional tribunal to conduct such a dialogue with the European Court of Human Rights or Court of Justice or the European Union. The question about if I imagine Poland without constitutional tribunal. Well, I agree with Professor Garlicki that we can imagine that. However, I would defend what Matthias said, that constitutional tribunal can be an important player in defending the constitution and in protecting individual rights. However, what lessons we have learned after the Polish crisis, it cannot be the only one body that interpret the constitution and individual rights. As Professor Sadurski wrote, Poland about Polish backsliding and the serious constitutional crisis. Well, we had crisis, and we still maybe have such a crisis when we see the constitutional tribunal. But I would say that rule of law in Poland did not die because of the work of individual judges in ordinary courts and because of the work of non-governmental organizations. So I would think that the Constitutional Court cannot be the only guarantor of the Constitution. This task must be taken by ordinary judges, but also by the non-governmental organization that can play an important role with it. So this is what I think about it. And this is why I would support such an institution, such a private initiative that can support the rule of law.
Thank you very much, Marta. It's very late, so I'm not going to summarize our seminar, but maybe just in reaction to the main elements of our discussion, I would like to say that probably it's easier to think about the Polish legal system without the Polish Constitutional Court, because nowadays in Poland, it's not the problem that the court does not function properly. The problem is that the Polish Constitutional Court is still a serious threat to the rule of law and democracy and the human rights. So that's why it's not just the problem of the functioning, as I said. But anyway, please allow me to thank our speakers for the very interesting contributions, and also thank you very much for questions, for comments. We would like also to invite you to the other seminars that we are going to organize in the framework of the project. In May, there will be a seminar on the Supreme Courts in Poland and Ukraine, and a lot of problems that we have also that are connected with those institutions. And at the end, I would like also to join and also to express my solidarity and our, I think, solidarity with the Ukrainian people, with our Ukrainian friends, academic judges, lawyers, and students. We all believe that the war you are experiencing will come to an end, and that you will be able to concentrate on building democratic institutions, including, of course, the Constitutional Court. So thank you very much again for participating in this seminar, and see you See you next time, I hope, also at our seminars. Thank you very much.
Thank you very much. Thank you. Thank you.
Thank
for
you.
your support and words. Thank you. Bye-bye.
Bye-bye.
Thank you.
Thank you very much.
Thank you.
Bye-bye.
Again.
Thank you.
Bye bye. See you next time.
Thank you. Bye.